Thank you.
All right, let's do this. So the learning objectives, I was struggling a bit in putting this together, just because there's so many different directions that you can take the conversation in, and there's so much to talk about when it comes to pretrial justice. And maybe I should have had a slide on this, but what is pretrial justice, right? It's really just what it sounds like, everything that happens pre-trial, right? Before the trial. In Connecticut, we have very few actual trials. Most cases are adjudicated through plea bargaining process. So you can think of pre-trial as anything prior to conviction, prior to disposition of the case. Okay. So we'll talk about the purpose of bail, purpose of pretrial justice. We'll try to get a basic understanding of how pretrial justice systems operate in Connecticut and nationally. And then we'll look at some Connecticut national trends in pretrial law. Why care about pretrial justice? Well, there are many reasons. But one is that it affects pretty much everything in the criminal proceeding. Right? It affects defendants, their families, communities, victims. Decisions about whether somebody is released pretrial or detained pretrial are really critical in the criminal justice system. I know here that 35% of the incarcerated population in Connecticut is being held pretrial. So it's a huge part of our incarcerated population. Detaining people pretrial is costly, and so there's a cost to taxpayers. We really want to make sure that we're detaining pretrial the most dangerous people, and it really should be the last resort. The question is whether we have that kind of system to allow for that. I know here that defendants who are detained pending trial are much more likely to be sentenced to a term of incarceration, and they're much more likely to receive longer sentences compared to those people who are out in the community. So if you imagine two people who are similarly situated, right, two people who may be charged for the same crime, they have the same risk, they have the same bond amount imposed on them. One person is able to make the bond and get released. The other person can't make the bond, they're detained. The person who is detained will get a much worse outcome when it comes to sentencing. Right? And that makes sense because if you're out in the community, you can take time and prepare for your defense. You can work with an attorney. You can attend whatever treatment or services that may be necessary to show a judge that you're addressing whatever issues there are. And even visually, it's very different for someone to show up for sentencing looking like this, right, versus somebody who's coming from jail who's already incarcerated. And there's also a tremendous pressure to take a plea bargain too when you're incarcerated. And there's plenty of research to show this. I also note here that detaining someone for as little as 2 or 3 days significantly increases the likelihood that they will reoffend. So essentially putting people in jail who shouldn't be there actually makes them worse. It makes them more dangerous. Right? Putting low-risk people in jail makes them high risk. And there's plenty of data to show that too. There's a little bit of on our work with the Sentencing Commission on pretrial justice. Everything started for us with a request from Governor Malloy to evaluate the pretrial justice system, taking a look at other jurisdictions, and then make policy recommendations to the legislature and to the governor. And so we produced several reports, one in 2017, one just last year on pretrial justice. We have submitted recommendations to the legislature. Some of them ended up passing in 2017. We made proposals to the Rules Committee of the Superior Court on bail. And it's just an ongoing conversation for the Sentencing Commission. We've been at it for a while. So this is a very busy chart, and I'm not sure everyone can see this, but this really explains how the system operates. I'm going to try to simplify this a bit. Essentially, there are different decision points in the system where somebody could be released or somebody could get detained. And there are different actors responsible for those decisions. The initial decision is with police, right? Let's imagine there's a custodial arrest, which means that the defendant is being brought into the police station to get booked and processed. The arresting officer has a choice to make. They can release the defendant on the promise to appear, or on what's called an unsecured bond, which functionally very similar to promise to appear, or the arresting officer can set a bond, and then it's up to the defendant to make the bond and get released, or if the defendant can't post the bond, they'll be detained. I'm going to skip another process that's in the middle, but we'll go straight to arraignment. That's really the next big decision point is with a judge. Right? There's an argument where a prosecutor makes a recommendation, public defender or defense attorney makes a recommendation. There's bail staff, we have a pretrial agency, they make a recommendation, and judge ultimately makes a decision on whether to release the individual. Again, a promise to appear, unsecured bond, or a judge can set a bond. And again, defendant may be able to post a bond, or maybe the defendant won't be able to post a bond, and then they're detained. We'll talk about this in a bit, but judges in Connecticut don't have an ability to detain someone without a bond. So that's if you take anything from this talk and discussion, remember that no matter how dangerous someone is, the judge will have to impose a bond, and then it's on the individual to be able to make it or not. Okay, what's the purpose of pretrial justice? This is very important because this should really guide every single decision making when it comes to pretrial. Well, we can think of it in terms of 3 M's. It's maybe the easier way to remember. There's 3 aspects to pretrial justice. One is to maximize public safety. Right? People who are getting released pretrial, we want to make sure that those people are not getting rearrested only within that period before sentencing. Right? So that's a key purpose of bail and has been for a long time. And it could be defined in a different way, but there's a public safety aspect here. Second major aspect of bail is maximizing court appearance. Right? We want to make sure that whatever action is taken pre-trial, people are getting released, we want it to show up to court. Right? And I put minimizing flight in parentheses because those things are related, but not quite the same thing, because people can miss court for all kinds of different reasons. They may have mental health issues, substance abuse issues, homelessness. People could forget, right? This versus somebody who's actively refusing to show up, right? And they plead the jurisdiction to another state or another country. That happens too. And so if the purpose of bail was only those 2 things, right? Maximizing public safety, maximizing court appearance, we would put everyone in jail pre-trial and be done with it. And that would maximize public safety because people won't get rearrested during the time and they'll certainly show up to court, right? But we can't stop there because the third purpose of bail really is also key, and it's to maximize release. So I have a quote here from the Salerno Supreme Court decision. In our society, liberty is norm. Detention prior to trial or without trial is a carefully limited exception. This was one of the key Supreme Court cases, U.S. Supreme Court cases, 1987, written by Justice Rehnquist, not necessarily the most liberal guy, liberal justice, but nevertheless, this is very much established that liberty is norm. And so we know that most people who are going through the pretrial system have to be released. We also know that detention prior to trial or without trial is possible if done right. The United States Supreme Court allows for that, but it's a carefully limited exception. And so the question is, how do you make those decisions? Who is to be released, who is to be detained? But keep in mind that we know that most people have to be released, and only some people could be detained. But in the history of bail, historically, release was done by using personal sureties and unsecured bonds. So personal sureties were essentially members of the community, could be family members, could be friends, of, could just be community members who are ready to vouch for the defendant and that they will show up to court. And unsecured bonds, we still have in Connecticut, bonds where they typically imposed at the police department level. Defendant doesn't have to put any money down. They're only liable if they didn't show up to court. And then in theory, there's a process to collect that, although that never happens. So in the past, it's been personal sureties as opposed to commercial sureties and unsecured bonds as opposed to secured bonds. As the United States expanded westward, there were less personal sureties. There was a real risk of flight, right? Because people were expanding, fleeing westward. And so that became a concern, so that in the late 19th century and early 20th century, we see a growth of commercial bail bond industry. Now, the rest of the world has abandoned that practice pretty quickly. And the United States stands as the only country, together with Philippines, to rely on commercial bail to administer pretrial release and detention. Which, people sometimes are surprised by that, but we're the only two countries that even have a profession of a bail bondsman. All right, so some trends in pretrial detention. I mentioned that the pretrial population, detained population, is now 35% of the total incarcerated population. And we've seen a really remarkable reduction in sentence population, right? In recent decades, pretty much a 50% reduction since 2008. But pretrial population have stayed relatively stable. So right now, it's close to 3,500 people are detained pretrial. They've not been convicted of a crime. They're presumed to be innocent. Sources of pretrial law. Bail is really a unique area in that it's governed by both the legislature and the judicial branch, and both branches of government have a lot of authority when it comes to how pretrial justice operates. So we have as sources of law the United States Constitution, of course, federal case law, Connecticut Constitution, Connecticut case law, Connecticut general statutes, and Connecticut practice book. And all of those sources of law are very important, and we'll take a look at this a bit more in the presentation. Federal Constitution is a floor for rights, but states can give more rights than their state constitutions. States typically have excessive bail clause, due process clause, equal protection clause that's found in the United States Constitution, and you'll see all that in the Connecticut Constitution. But what we'll focus on more now is the constitutional provision on the right to bail. That's not in the United States Constitution, but is in the Connecticut Constitution. So when it comes to the right to bail provisions in state constitutions, you can roughly split states into three different categories. Some states have simply don't mention the right to bail in their constitutions. New York is one, for example. There's 9 states like that. Other states have what's been often referred to as the broad or traditional right to bail. Connecticut falls into this category. And then we have some states that have amended their constitution. They still have a right to bail, but they amended their constitutions to expand the pool of defendants who could be eligible for pretrial detention. So here's the Connecticut provision on the right to bail. Article 1, Section 8A of the Connecticut Constitution guarantees the right to be released from jail to reasonable bail to virtually all defendants except in capital offenses. Now, we don't have capital offenses anymore since the state abolished death penalty. So really what that means is that there's now a reasonable bail for all defendants in Connecticut. As a result, under our state constitution, judges are barred from detaining a truly dangerous defendant with the financial resources to post a high bond. To allow for purposeful, intentional detention, a constitutional amendment would be needed. So what's reasonable bail, right? We know that everyone will get reasonable bail. No one can be detained without a bond in Connecticut. What makes a bond reasonable? And I have a picture here of, you guys know what this is? Familiar? Anybody virtually? Who is it?
Sacco?
Nope. So it's a famous author. It's Kafka. And this may seem a little bit random when I have Kafka next to reasonable bail, but I will explain what Kafkaesque means to my daughter once, and I immediately thought of bail. And so I was explaining what Kafkaesque means to her in terms of our pretrial justice system. And I think you'll see here why. What makes a reasonable bail? Well, we know that courts are prevented from fixing bail in an unreasonably high amount so as to accomplish indirectly what it could not accomplish directly, that is denying the right to bail. So this is straight from a Supreme Court decision, Connecticut Supreme Court decision last year. What that means is that judges are not allowed to come up with a bond amount on purpose to detain someone. And that is so you cannot do indirectly what you cannot do directly, which is deny somebody a bond on purpose, right? Does that make sense?
Mhm.
So we know judges are not allowed to do that. Now, does it have to be a bond that somebody can afford then? No. The court has been very clear in that defendants are not constitutionally entitled to a bail that they can afford. Okay, so you cannot set it high enough on purpose to detain someone. It also doesn't have to be a bond that the defendant can afford. So what makes it reasonable? Well, what makes it reasonable is that it's reasonable under all circumstances relevant to the likelihood that the accused will flee the jurisdiction or otherwise be in prison for trial. So this is about flight and court appearance, the purpose of bail that we talked about. And then the imposition of a bond for the purpose of ensuring public safety is a constitutional sound practice, the court said. So you can set a bond for public safety purposes. You can set a bond for to prevent flight. It does not need to be a bond that defendant can afford, and you cannot set it on purpose to detain someone, right? So this is why I have Kafka here, right? Imagine there's a defendant before a judge who is truly dangerous, and imagine somebody like Adam Lanza, right? Adam Lanza survives, and Adam Lanza is before the judge, and clearly there's a concern that as soon as you let the defendant out, he might be doing something terrible, right? So according to this, the judge is not allowed to set a bond that's really high in order to detain that person. That would be excessive bail, that would be unconstitutional, and that would be overturned. And it doesn't have to be a bond that Adam Lanza can afford, right? So the judge sets a bond, probably will be pretty high, without clearly stating his intention on the record, even if he or she is very interested in detaining that individual. And if that high bond results in defendant's detention, then it's fine under our law. And if that bond results in the defendant's release, that's also fine under our law. And that's why I have Kafka here. It's really try to figure this out. All right, so national trends, we're in one of the most active periods around constitutional statutory changes in recent decades. I mentioned some jurisdictions here that have either moved away from money bail entirely or have attempted to do so. The District of Columbia has been doing it the longest since early 90s. It's an in or out type of system. New Jersey has done it since 2017 now. New Mexico around the same time as a result of court decision. New Jersey, by the way, had identical constitutional provision as the Connecticut. So they've gone through the process of amending their constitution to create an in or out type of system. California attempted to do the same. They passed a pretty comprehensive bill to create an in or out type of system, but then they had a referendum and it was overturned. So more work remains to be done in California. And Illinois was going to be the first state to truly eliminate money as a tool of release or detention. And that was supposed to go into effect January 1st of this year. There's some litigation happening now, and so there's a stay. But I think their reform will survive, and we'll see how that goes. But there's been a real move around the country to try to either eliminate money bail or move away from it, so that the system is more fair and rational and safe. We've also seen a lot of litigation challenges recently, especially in the last 5 and 10 years. Most of the litigation that we're seeing allege due process violations and equal protection violations. And they're often winning. There's a lot of settlement all around the country. Certainly, Connecticut is vulnerable to that litigation too, although we have not seen that much of it yet. All right, so some recent developments in Connecticut when it comes to pretrial justice. I'll talk about two. One development is with the 10% cash bonds through the Rules Committee, and then we'll talk later about the constitutional amendment in Connecticut. So this is the language of a rule on 10% cash bail that the Sentencing Commission has introduced several years ago and ended up passing. So the Rules Committee within Superior Court is the committee that recommends changes to the rules that all Superior Court judges have to ultimately adopt. And you can think of those as regulations for executive agencies. It operates in a similar way. 10% cash bail is an option available to defendants to pay a 10% to the court instead of bail bondsman. And the difference between the two is that defendants who go with 10% cash bail get their money back at the end of the case, right? Versus assuming they show up to court, versus going through bail bondsman where you pay a non-refundable fee, you never see that money again. So 10% cash bail was available in the practice book before the Sentencing Commission got involved, but it was very rare. It was only available at arraignment and only by request. So the defendant had to make a motion, and it just wasn't part of the court culture. There were almost no 10% cash bonds. What we did in our proposal is that we made 10% cash bonds available right at police department level. So when people get arrested, they can post 10% cash bond with the court and get released right away. They don't have to wait until arraignment. And we made it an automatic option for bonds under $20,000, so that defendants don't have to ask for it. The bond is low enough. They can go to bail bondsman, or they can go with 10% cash if they can put enough money together and get their money back. And in the next few slides, I'll go over a little bit data that we've collected and analyzed here on 10% cash bonds. We wanted to make sure that we track the implementation and then there are no unintended consequences. And so here you see bond type, promise to appear, non-surety bond. This is the unsecured bond that I was talking about, where defendants don't have to actually put any money down. They're only liable, they don't show up. Then we have professional surety here, and then 10% cash option, and then the last one is cash only bonds. There are almost no cash only bonds in Connecticut at this point. So you can see that before 2020, there were no 10% cash bonds at all. That was not available at the police department level. And then this is the first quarter, and there was just a steady increase in the utilization of 10% cash bonds, to the point where in most recent quarters, more than 1 in every 4 releases utilized the 10% cash option. So it went from 0 to now more than at least 1 in 4, at least in the most recent quarters. Now, if you just look at financial releases, so these are cases where actual bond was imposed, how people get released. So we're eliminating promise to appear, we're eliminating unsecured bonds. So we're only looking at people who use the professional bondsman or 10% cash bonds. Again, from before 2020, there's no 10% cash bonds available at the police department. And we're starting to see a real increase in 10% cash bonds, to the point where about 60%, almost 60% of people who posted a financial bond at police departments now utilize 10% option. And so these are people, all these people utilizing 10% cash option would have gone to the bail bondsman. Presumably, they would have paid a non-refundable fee. They would have never seen that money back. Now all these people are paying directly to the court, and if they show up, they get their money back. Okay, there's some data here on utilization by race and ethnicity. And there is a bit of a disparity that white people tend to use 10% cash option more than Hispanic people and Black defendants. Here we looked at 10% cash bond utilization by bond amount. And essentially what you're seeing here is that, so these are bonds under $20,000, right? What you're seeing is that for bonds that are very low, people are finding enough money to get together to pay the court, because you need 10% of the bond. For higher bonds between $15,000 and $20,000, people are still going to bail bondsmen because they require a lot less of down payment than 10%. So this really to me shows how little money people have in the system, and that they can put together typically $100, a few $100, and get released through a 10% cash bond, but they don't have enough money to put together a bond, 10% cash bond when it comes to bonds between $15,000 and $20,000. Even though they know they can get their money back, they're still going to bail bondsmen because they can put together a few $100 and get released, even though they're losing that money. Here, the utilization of 10% cash bonds is broken down by police department. And what you're seeing here is that the largest cities tend to experience 10% cash bond utilization at lower rates than suburban police departments, probably because defendants in suburban police departments tend to have a bit more money than defendants going through the system who are arrested in our cities. Here we look at failure to appear rate and rearrest rates, and it really didn't seem like 10% cash. People who gone through 10% cash bonds appear in court at any different rate. They're not rearrested at any higher rate. So really, there haven't been any unintended consequences that we've noticed. Perhaps the most important number here, we've estimated that close to $4 million has been returned to people since the implementation of 10% cash bonds in January of 2020. And that's only through September 2022. But now I'm sure it's much more. And over $2 million is being held in patient of case disposition. It's really been, at least in my mind, reform that's been remarkably successful in that people are getting their money back. They're showing up to court at the same rate, and they're not rearrested at any higher rate. So that's 10% cash bonds. We have a new proposal in front of the Rules Committee right now. And that proposal does two things. It reduces the percentage required to post with the court from 10% to 7%, which will really increase the pool of defendants who will be eligible and who will be able to post 10% cash, well, 7%. And then we're also raising the threshold from $20,000 to $50,000 that allows for defendants an automatic option for 10% cash bond. And that's now before the Rules Committee. We've appeared now before the committee a couple of times. There's a public hearing in May, and I'm sure we're going to see every bail bondsman in the state show up and testify against it, because this really hits the industry hard. All right, let's talk about a constitutional amendment. This is very timely because Judiciary Committee just heard for the first time ever a constitutional amendment on bail, and actually passed it out of the committee. And this is it. This is the language. The way to read this, everything that you see that's bracketed is the language that the proposal takes out, and everything that's underlined here is new language that's being added by the proposal. So in the beginning, we have a few technical changes here. And then this language is being taken out. So if you read it, the original amendment, it says, in all criminal prosecutions, the accused shall have a right to be released on bail upon sufficient security, except in capital offenses. So this is the existing constitutional provision, right? Everyone has the right to be released upon sufficient security, except in capital offenses that we don't have anymore. So the amendment says, here, the accused, so that the language is being taken out, it's bracketed, right? The new language, the accused shall be eligible for pretrial release, except the court may deny pretrial release to the accused if the court finds no conditions of pretrial release reasonably sure that appearance of the accused in court, when required, or protect public safety of any other person in the community. And so those are the two purposes of bail that we talked about, court appearance and public safety, or prevent the accused from obstructing or attempting to obstruct the criminal justice process. So what this constitutional amendment does is it sets the stage to move the state towards a system where intentional detention is possible, right? So that down the road, if this is passed and adopted, and the legislature comes up with a statutory structure to implement it, this would allow for in or out type of system where some dependents will be released and other people will be detained, not with money, but purposefully as a result of a hearing. And so this presents really a tremendous opportunity to make the system more fair and more safe. At the same time, it's a bit scary because if it's implemented the wrong way, this could create a system that's arguably a lot worse than what we have today. Could lead to over-incarceration. I think I have 1 or 2 slides more. Here I talk about some of the things to consider as the state potentially moves towards in or out type of system. First key question is what would be the detention eligibility now? Right? What type of offenses would qualify for detention, and what offenses would not qualify for detention? Here I present a few options. One option is to say everybody, no matter what you're charged with, is eligible for pretrial detention. Right? Misdemeanors, felonies, no matter what the level of the crime is, you're eligible for pretrial detention. Another option is just to focus on felonies. Say misdemeanors cannot be detainable, but felonies are. A third option that I would recommend is to focus on some kind of violent or very specific offenses, and that would be your detention eligibility net. Everyone else is ineligible. The next key question is what would be the legal standard for detention? Right now, bond just has to be reasonable, and a reasonable bond, as we've seen, can result in detention, or it could also result in release, and pretty much everything is reasonable. There are very few excessive bail cases. Here, if you're talking about a hearing where liberty is at stake, right? You're trying to show that this person is too dangerous to be out in the community. It's going to have to be a much higher legal standard. So one that I'm presenting here is the clear, convincing evidence that no conditions can address an extreme risk of flight or serious harm to identifiable persons or property. So focusing on the risk of flight rather than just failure to appear, and focusing on specific serious harm to specific people, right, as a potential standard. And then the next set of questions are around what types of hearings would this involve, what evidence could be presented, who would have the burden of proof. Do you have presumptions in favor of release for everyone, or will there be some presumptions in favor of detention? What would the appellate review look like? All this would need to be worked out. I talk about conditions of release here because even though conditional release is a substantial improvement over detention, over conditioning can be counterproductive, right? You don't want to impose conditions that are unnecessary because that could lead to criminal consequences. Right? You can require someone to go to treatment, and then the people don't show up to treatment. There could be consequences, right? And so I mentioned that here because in a system without money bail, it's essentially just in or out. There'll be additional pressure on judges to impose additional conditions, and it's just something we have to guard against. Risk assessment tool, we're going to have a whole discussion about risk assessment tools, but we do have one in Connecticut, and the question is what should be the role of the risk assessment in this new type of system, in or out type of system? What role should, if any, risk assessment should play in that system? There's a very robust debate happening on that. Defining pretrial risk, perhaps this is the most important one here. What is the type of risk that we're concerned about that we would want to detain people on? What is ultimately at stake here? We can focus on failure to appear, but as we know, people don't show up to court for all kinds of reasons. Or we can focus on flight. And then same with public safety. Do we want to potentially detain people on any kind of rearrest, or do we really care more about kind of violent felonies, like violent conduct? And finally, the use of money. What would be the role of money bail if we set up a system where there is intentional, purposeful detention? I'll end there, and hope we can have a discussion. But I'll be glad to answer any questions.
Thank you.
How do we check if there's anything like comments or?
Maybe stop sharing. If you're joining us virtually and have any questions, please feel free to put them in the chat or unmute yourself and ask there as well. But does anyone in the room have any questions?
I have a couple. Even though we've talked about this a bit, I always learned something new. One is on the lines of maximizing public safety. Is it not being an attorney, being a part of these processes that often? I can imagine rhetoric is used for the public safety argument, but you presented actual evidence in terms of public safety and people being less safe the more time they spend in prison. So wondering if that is ever utilized as an argument, and could be in terms of guarding against excessive incarceration if there is a conflict.
Right. Yeah, I don't think that's been ever really well fleshed out. Like, what is the public safety risk? We know that we don't want people getting rearrested, right, during their pretrial period. But what does that mean? Right, like what kind of risk here do we ultimately care about that would make someone detainable? Right now, there's not much to an arraignment in terms of like these arguments about whether somebody's too dangerous or not. Prosecutor will make an argument for bond, right? Public defender will make an argument for no bond or lesser bond, but it's the same language that's kind of being recited. Like this is a serious offense. That they would look at the history of rearrest for the defendant, and that's kind of it. And the bond will be imposed, and then kind of whatever happens, happens. But one of the big issues here that we have in our system is that we sort of are okay with either outcome, release and detention, right, for any given bond. And then so you would always have some people who are released who should probably be detained, right? But they have the means to purchase their way to freedom, at least on the pretrial side of things. And you will always have some people who will be detained who will be released, right? Because there could be a very low bond of, let's say, $1,000, and maybe most of us in the room will be able to make it, but there will be a few who won't. And so you always have, for any given bond, some people will be detained, and some people will be released, similar situated people. So how do we care really about public safety that much, where we're saying that for any given defendant, whenever bond is imposed, as a system, we're saying either outcome is fine, right? Does that answer your question?
Yeah,
So-
I guess it goes to the idea of like an individual decision versus the balance of the decision. So if you're making an argument that an individual is dangerous, how are you making that argument? But how do they balance that, knowing as well with clear evidence presented that any time in jail is actually more of a risk for public safety to the general public?
Yeah.
So I just kind of wonder if courts wrestle with.
Yeah, moving towards an NRL type of system presents an opportunity to finally create a process where we actually do care about public safety, right? Where prosecutor will actually have to reach a certain standard, most likely a pretty high standard, to show that not only that the risk is very, very high, right? Like it's got to be reserved for the most riskiest, most dangerous people. And even there, that's not enough, because we have all kinds of tools to address those types of things out in the community, right? So you have to show not only that there's a very high risk, but also that no conditions or combination of conditions can ensure public safety for that individual. And it's going to have to be a very high bar, right? But the constitutional amendment allows potentially to an opportunity to set up the type of system.
I'm just curious. I was thinking in a science term, do they have like a judge have this standard thing? This is for this. This is for the amount for putting the bail. What if in that moment he was not? Oh, I'll just put a bail on that. Does he have a like a standard or a book or something that says if this is the income of this, how many times it's been? How do you set the bail? I mean, is it like the whim of it? I know you said it's not, but then you never know. You're a human being too. But if you have a set of standards, do they have that?
No.
No.
No, but,
Then you're screwed if it's not your day.
well, so I can explain how that works. Judge makes a determination ultimately on what bond is going to be, right? Based on the argument that happens in court, and prosecutors will make their own argument, and they may have their own internal system for setting bonds. Public defenders, defense attorneys will also make a recommendation, and the other party that participates in the process, the State's Pretrial Justice Agency, CSSD, and they do sort of have a system to at least standardize bonds that they recommend. Now, what they did is they created a table called Financial Bond Guidelines, where in the one axis they have a charge, and on the second axis they have a risk level, right? So that for consistency purposes, they filled it up with bond amounts, and they basically looked at what judges have given in the past for people of certain charge, certain risk, and they created this table. Now, that seems like a good idea to make sure that people of the same charge and same risk are getting the same bond amount, right? At the same time, it's never been shown that bond amounts have any relationship to what we care about, pretrial outcomes, right? Or failure to appear or rearrest rate. Like we have no idea, for example, in any given case, whether a bond of $50,000 would be better than $10,000 in terms of achieving any particular outcome. So for consistency purposes, CSSD, Court Support Services Division, created this table, and that's what they use for their recommendations to the judge. Ultimately, it's on judges to go with that recommendation. But even if you standardize everything so that people of the same charge and same risk get the same bond amount, you'll still have different outcomes, because some people, like imagine we're all charged with a Class B felony, and a risk assessment is conducted, and our risk is -10 collectively for our group. It's still going to be the case that some people will be able to afford it, and some people won't. So you can standardize all you want, but it comes down to defendant's ability to pay, which is not any kind of consideration in the criminal proceeding in Connecticut. Like it doesn't matter what you can afford, nobody's going to investigate that. Ultimately, it's still up to individual to make that bond, and if you can't, you detain.
Is there a maximum amount of time that a defendant can be detained if they financially can't afford the bail?
You sit there until the disposition of your case. If you want to take it to trial, you can. But right away, imagine you're detained. First thing you want to do is get out. If you have a defense attorney, first thing they want to do, it's a good attorney, they want to get you out because they know you're going to get a better outcome. And of course, you want to get out to be with your family, right? The longer that you're there, the more pressure there is to take a plea, right? Which is how our system operates. But you could be waiting. You could be sitting there several years waiting for trial if you want to, and then there could be a disposition of one day you go to court. The disposition could be time served, and you go home. Judge decided that you already spent this time waiting for trial. The case is resolved. So there's a lot of that happening too.
But it could also just be that like goes the other way, that it's not time served and kind of.
Yeah, you'll sit there until you take a plea bargaining agreement, or until you go to trial. And there's so few trials in Connecticut.
I have questions. For people in those lower level offenses that don't necessarily show risk to society, is there any considerations of like families? Like I'm thinking children, because that's kind of, what I mostly thinking about. Is there any considerations of that? So if you have like a single parent who is the sole caretaker, but their offense is like, I don't know, writing a bad check. I'm just kind of throwing it out there. And they can't afford bond, but they're serving some sort of time. Is there any consideration of like the impact on the families, on the kids, which we know that keeping parents away is most likely to impact public safety negatively than actually releasing that parent? Is there any considerations of that or any discussions?
There's nothing in the law to require a judge to consider those mitigating circumstances, but a judge certainly can consider it. If the defense attorney would make a clear argument and that look, my defendant cannot afford this bond, this would result in incarceration. They have a family, and a judge may take that into consideration, but they really don't have to.
Okay.
Alex, is the time between arraignment and disposition of the case, that duration, is it at all relevant on this question about pretrial detention? I don't know if there's a kind of standard length of time.
There's no standard length of time, and it really matters in terms of whether you're detained or released, right? If you're released, you're out in the community, and you could go to court, which may be burdensome, but it could be, it's usually quite a number of continuances, and it may take a year to resolve the case. But if you're sitting in jail, it's a whole lot of calculation, right? Because you really don't want to be there, and so the pressure to take a deal that the state is offering is just really tremendous.
I was thinking though, if somebody knows the disposition's a year off in one instance, somebody else knows the disposition is going to happen in a month, they may have a different attitude about it.
Yeah, but you never really know. You never know when your trial is coming, or a very serious, complicated case. It could take a really long time.
This might be more like an exceptional kind of case. I was wondering, are there any cases where the judges prohibited that 10% bail option? Which might kind of be just some concerns. Were there cases?
Yeah, so right now, for bonds under $20,000, defendants have an automatic option. Right, for bonds over $20,000, you don't have that automatic option to post 10% cash. You have to ask a judge, and it's up to a judge. And they have rejected 10% cash requests before. In fact, at a quote from a Supreme Court case that came out last year, where a $20 million bond was imposed, and the defense attorney asked for a 10% cash bond, and the Superior Court judge said that he didn't have authority to grant it, and basically was wrong. And the Supreme Court has noted that they said, of course, you have a choice. It's up to the judge, and I mean, very clearly law. He could have just denied it easily, but he said, like, I don't have authority. So it went up all the way to the Supreme Court. But functionally, imagine as a judge, you have somebody like Adam Lanza, right? To not want to detain someone like that, or at least to think about it, I don't know what kind of person you have to be, right? So at least it enters your calculation, right? Well, what's not allowed is to make a record of your intentions. But no question about it, when you hear really high bonds, most likely the intention is to detain, and so they'll probably reject some 10% cash bond requests. Because at least in certain cases, when you hear $10 million, $20 million, that's clearly, to me, an intention to detain. Problem is that you'll never hear that in courtroom. Judge is not allowed to say, I'm setting the $20 million bond, because I don't think you should be getting out. You're too dangerous. That will be overturned right away. That's an easy case. And so everyone sort of pretends like they're setting a reasonable bond in those cases, and if it happens to lead to detention, that's fine. But the problem was that it leads to release of some people at least. Like some people actually can make $1 million bond, and they do.
I have one more question.
Hmm?
Where will the unrefundable bonds go?
Unrefundable bonds?
Yeah, where will that go? If you're like, you have a 20 million bond, where will that bond go?
What do you mean by
Yeah,
unrefundable?
like you have 10%, you can get the money back, right? You
Mhm.
said. But what about those that are not 10%? It's just the bonds. Where will that go?
So the bondsman?
Yeah,
Right, so there's two release mechanisms for people, right? When a bond is imposed, some people can qualify for 10% cash bond where they pay directly to the court. They can hopefully get their money back. There's no fees or anything. You pay 10% cash, you'll get the whole thing, you'll get that back. For other people who are not either don't qualify, don't get the 10% cash bond, they go to the bail bondsman, right? Because most people say a bond is imposed of $1 million. You can post $1 million, get that back in the end. You can post a full bond. Almost no one does. So people go to the bail bond industry that's specifically set up to do this type of work, where you pay them a percentage of the bond. It's usually around 7%, although it's a lot less because they take payment plans and often undercut each other sometimes. So you pay the bail bondsman fee. That's their business, right? That's what allows them to be that's their job, right? They collect this money from you that you'll never see again, and then their job is to make sure that you show up to court, and if you don't, in theory they're liable, although it gets a little bit more complicated there too.
That also defies logic because if you're never gonna see that money back, it's your going rather than 10% that you think of.
Right, it also doesn't address public safety, right? Because if you're released through a bail bondsman, it is not in their charge to make sure that you don't commit other crimes. They don't care if you alleged to commit a murder, you're charged with murder. If you commit another murder and you're under supervision of a bail bondsman, they could care less, right? And in fact, it may be a good thing for them because now they don't have a responsibility to bring you to court, right? And there may be additional business because there'll be another bond on the new murder. So it's really not part of their part of what they do at all.
Well, their goal, right, is just to ensure that at the end of the day, the money is to make sure you go back to court.
Mhm.
I think the flaw from what you've said in the system is that if you, let's say you have $150,000 bond, bail bondsman comes in and usually can bond you out 5%. So you're going to pay what, $7,500. You're probably not going to see that $7,500 back, but you get out of jail. Bail bondsman, that's its fee. You go to court, do everything you have to do. That's the end of it.
Mhm.
You lost $7,500 in order to not have to sit in jail prior to being tried. The problem, I think, is that but the incentive is that if you don't show up to court, right? Bail bondsman's on the hook for the 150, and he should have collateral. He can go after your home, your cars, your bank accounts, whatever to get it. I think what you're saying is that most of the time, although it doesn't happen frequently, if you don't show up for court, right, you violate the terms of your release. Very infrequently is the bail bondsman actually on the hook for the money.
Right.
So that's the problem, right? To me, that's the flaw. It's like if the system was the money is to ensure that you come to court and you see this thing through. And you don't, then there's a penalty, right? The court goes after the bail bondsman, the bail bondsman has the right to go after you. Except if we don't do that, then all we're really saying is you just have to pay more money to some entity that makes a living off of helping you get out of jail. It's really silly.
Yeah, in terms of showing up to court, the interventions that really are evidence-based and work best are pretty simple. You make phone call reminders to people, right? You arrange for transportation. You address whatever issues people have that may prevent them from going to court. And the reality in today's criminal justice system versus the system, back in the late 19th century, is that most defendants are poor. They don't escape to Mexico, Canada. They don't show up to court. They go right back to their communities where they are. Eventually, they picked up on another charge or on a warrant. There are very few people who actually trying to escape and go to like a country or Puerto Rico, right? So we do some court reminders and notifications, not across the board, but really those are the types of things that work. That if we really want people to show up to court and we do it's a legitimate purpose of bail, there are other things you can do other than get a bail bondsman as well. But it's a very strong and powerful industry and lobby in the legislature, and they make their presence known in the system.
Yeah, well, I think the other piece too is that the risk component, right? Meaning you move to a risk-based system where a judge looks and says, I think you're a higher risk, and therefore I'm not releasing you based on public safety factors, for example. I think there's a reasonable argument that's been made, which is why there hasn't been consensus on the issue from like the public defenders, right? Who are saying we're not convinced that the system, if we move to a risk-based system, isn't going to continue to be biased against Black and brown people.
Right.
So you have this issue where everybody sort of understands the current system and the unfairness built into it. But that is more palatable to many people because they're afraid that if you move to a purely risk-based system, that because we inherently as a society have viewed Black and brown people as more dangerous, that judges will too. And there'll be more people locked up in those communities pre-trial. Now, that might not be true, right? That might all turn out to be false. There may be safeguards you can put in place, but I think the problem in this discussion is that you have fears on both ends.
Mhm.
It's the system over here isn't working, it's kind of being abused and has all these holes in it. And then on the other end, it's, well, if we move to this risk-based system, how do we know it's not gonna just cause other problems?
Well, I think the thing to keep in mind of that is the US is still the world's leading jailer, including pretrial. And in the places that don't have the bail system, their pretrial population is a lot less. So I think there should be some comfort in the things.
Because other places, particularly like European countries, don't have the same racial tension that we have in America and the same racial bias built into the criminal justice system. So as much as that's true, right, Europe doesn't have the same historical race problem that we have in America.
You can certainly, if we look at the federal system, which is in or out type of system, there's money bail as a tool for judges that's available, like for release mechanism, right? So if you think there's a real concern with flight, you can impose a bond on someone. But if you want to detain someone in the federal system, you have to go through this hearing process, you have to reach a certain burden. So it's an in or out type of system, but the federal system has huge incarceration rates, right? And granted, these are different quality of crimes, right? Much more serious on the federal level, a lot of immigration cases. But that's a system, for example, that would hate to emulate in Connecticut. And you can imagine other scenarios where things could get worse, right? We're gonna have a system where everyone gets a risk assessment, and if you score -10 or below, you're presumed to be detained, right? And everyone else is walking around on GPS, right? Who's out in the community. It could really, that's why I talked about some of the elements that would really need to be figured out, because it's all going to depend on who's eligible, what the legal standard is, what types of hearings are these. And it could lead to a reduction in pretrial population and much more intellectually honest process where it's clear what everyone's doing in the courtroom, right? But I'm very nervous about what's to come, especially since what we've seen from the Judiciary Committee is just a constitutional amendment. And like, for example, New Jersey, where they had a constitutional amendment and they worked out what the system would actually look like at the same time. We only have a constitutional amendment, nothing else. And I'm afraid that the whole conversation is too focused on public safety, right? So there's a lot of talk about how come we have people who are dangerous, who are posting high bonds, and they're being released, right? And that's a problem. We do have people, very high bonds, several $1 million, they're posting that and they're being released. But the bigger problem is probably with people who are being held on low bonds, right? And there hasn't been as much conversation about that piece. And so if the whole thing is about public safety, then like the implementing statutes of this constitutional amendment would kind of focus more on that aspect, which is dangerous.
And isn't there a belief or theory that the risk assessment tools are even based on data that inherently is racist? Or
Well,
like,
it's based on the risk assessment factors. Like even if you look at the risk assessment in Connecticut today, first, of course, it uses historical data, right? So how many times have you failed to appear, what, your rearrest record. It also has a lot of socioeconomic factors. So actually the first question of the Connecticut risk assessment is, are you married? And if you're married, you get 3 points, and if you're not, you don't. Well, the idea is that you have closer community ties, so you're less likely to flee.
Not getting married.
I should tell you that I'm getting divorced.
Right, so all about what? So that's the first question, and then there are factors like employment, right? And no one has really done an analysis to see, well, what's the impact of those factors on the risk assessment? And right now, it's the risk assessment is more of a release tool, I would say. But we have traveled to jurisdictions that moved away from money, and one was New Jersey. And to me, it was very apparent that in New Jersey, risk assessment plays too much of a prominent role because it's something that attorneys argue about, and once it's announced in open court that your score is minus whatever, and it sounds bad, right? That could even though risk assessment score itself doesn't tell us anything about the defendant, right? It just says that the defendant falls into this category of people like this. And so it's not necessarily an individualized decision. So there's a big debate happening on risk assessment and whether it should even be used at all in the pretrial process. But it is to be used, it should be a release mechanism. It should never be the source of detention. Right? That would be the worst type of system, was if you score below something and you go to jail. Especially given the fact that we know these tools are not perfect. It could be improved, but they have really severe limitations when it comes to detention decisions.
Curious, you mentioned a lot of cases and due process and the right to fair trial and things like that. Has there ever been anything brought on what you're able to wear to court? Because it doesn't seem to be a fair trial if someone can come in like a suit and tie, and that same similar situated person has to come in and jail.
Right. Yeah, I have not ever heard of that conversation ever happening in Connecticut, but that's one of the things that will be held against the defendant, right? Whether you want to or not. Visually, the two people may be really the same.
You're also usually shackled too.
Exactly. Exactly. In addition to all the other things you can do in the community, right? If there's mental health issue or substance abuse issue, you can go to classes like to see a therapist to address those issues. Right? And you can take care of your family and maintain your job, right? And go to school versus somebody who's detained whose life is completely disrupted. Right? Two people who are maybe really identical in terms of their risk, but not identical in terms of their ability to post a bond.
Nationally, there's been some work on that, allowing people who are being held to wear street clothes, if you will, allow a family member someone to drop off clothes for them to change into, but I don't know about Connecticut.
Has New Jersey implemented any tools that you think Connecticut should look towards? Because you didn't mention the risk assessment, which doesn't seem as, very promising, but is there anything else that I've done that's like, maybe we could look towards?
New Jersey utilizes Arnold Foundation risk assessment tool. And they've really, pushed it all around the country as a kind of a model. And I should say, pretrial risk assessment is it's a relatively common concept in the criminal justice system, especially when you compare it to risk assessments in, for example, sentencing. I don't know of any jurisdiction that utilizes risk assessment for sentencing purposes. So it's much more controversial in other aspects of the system, but here, you only have really a few purposes, right? To adjust public safety, is to prevent flight, and to encourage release. So risk assessments in the pretrial field is a much more established concept, but in the last few years, there's been a lot of pushback against risk assessment as kind of a key aspect of pretrial reforms. And my views on this also continue to kind of evolve. I used to think that it's a necessary part of the system. Maybe the risk assessment should be improved, but it's really key to maintain it in some way, and I'm not so sure anymore. I think at the heart of release and detention decisions could really be the hearing itself, and what kind of hearing would this be? Right now, if you go to arraignment in Superior Court, it could take for like a minute and a half for this proceeding. It's very quick, right? You've seen it.
Yeah, they're super quick.
It's a huge volume. You have prosecutor who hasn't met the defendant. You have public defender who usually hasn't met the defendant yet, right? And everyone sort of recites the same language, and it's very, very quick, right?
They do like hundreds a day.
Right.
Yeah.
Right. So it's now you compare that to a system where like in New Jersey, where to detain someone, prosecutor has to reach a certain burden, and you have to show very concrete things. And we've seen a few hearings that lasted half an hour or more. And I think that's what's at the heart of like these decisions, or could be at the heart of these decisions, is what's the legal standard? What do these hearings actually look like? What do you have to prove? And the risk assessment could be a tool of release, right? But I have a lot of reservations, to say the least.
Thank you. Well, thank you everyone for coming. Thank you for your questions, and thank you so much, Alex. It was so informative. I have way more questions, but we don't want to keep everyone. Yeah.
Thank you.
Thank
Thanks,
you.
everyone.
We love you.
I know, I have so many questions.
Yeah.
Uh,
Is there, do you have in mind what you would like to be? Like,
What I would like to